Now, who owns the rights to your invention if you invent while being an employee on the job? Hi, I'm JD Houvener, owner, founder, and patent attorney at Bold Patents Law Firm. I'm also the author of Bold Ideas, the Inventor's Guide to Patents. And I've got the Bold Inventor Kit for you to download at the link below of this video. It's got the whole book, the whole PDF of this tutorial, as well as really important guides for patent searching and patent prosecution as well. So take a look at that, and click the link, and get started today. So this question is important, very important. There's lots of inventors within companies. And this question about whether you own the rights is really key. We get it quite a bit. A lot of employees or contractors will contact us to say, hey, look, I invented something. It happened while I was on the job. Who owns it? Can I file a patent application for it? So we want to, before we start filing patent applications, we need to understand ownership of inventions. Typically, if it's a W-2 employment with your employer, almost every case, you are likely going to have an obligation to assign your invention back to your company. There are a series of questions that we go through to check and make sure this is proper. If you did invent it in the furtherance of your job, in other words, if your job is to be a design engineer or an R&D or research and discover, find, invent, that is exactly what your employer is gaining by compensating you for your salary, bonuses, and whatnot. Also, your employment agreement is what's really going to govern. And so having us or a business attorney review that and inform you of your rights, take a look at those clauses, specifically assigning invention, assignment of intellectual property while on the job, while using their equipment, tools, or other items that are associated with being paid, compensated during the time. So if it was during the time that you're being compensated, using their tools, meaning software, computer, even the phone, really basic stuff, they are likely going to have a really good claim to owning, and therefore having you obliged to assign, meaning transfer ownership, back to that employer. Now, if you're in a contractor position, this can be a little bit different. Typically, you're not obligated to assign intellectual property when you're a contractor because you don't have the same obligations. Typically, you don't have that ongoing employment obligation either, right? So either way, it's sort of this temporary contractor type of experience. And so you want to review that contract, of course, to see whether you're obligated to assign or transfer ownership of inventions that arise while you're doing and completing the contract. Now, if you have an invention that comes up totally separately from that specific contract, likely you will own that and be able to commercialize it independently from the company. You do need to be careful, of course, that if the discovery, if the spark of that conception came about while in furtherance of that contract, there may be some way for that company to have a way to own it or seek those rights after you file the patent application. So think about this carefully, get an opinion from a lawyer, understand where you are in terms of the ownership. You likely don't want to proceed and hire a counsel, hire patent attorneys, file application and expend your own money if you're going to end up having to assign it back to the company anyway. Now, I have seen sometimes where employers will waive the rights to ownership, just being completely upfront, saying, talking to your boss, talking to your manager or the owner of the company, and it's like, I came up with this invention. Do you or does the company plan to commercialize it? And they might just say, no, we're really focused on what we're doing in business, and we have no intention of moving forward and filing a patent for what you've come up with on the job. We're willing to waive our rights and allow you to commercialize this on the side. And if you'd like to, someday, maybe moonlight or have your own company around it. And in that case, you probably want to also have a conflict of interest waiver in case you end up competing with your current employer. So there are ways around it. You can be upfront about it, but make sure you understand your rights up front. Hope this was educational, and for all those employees and contractors out there, keep innovating. And I should say, without wrapping up, before I wrap up, if you do want to make sure your inventions are completely not your employer's, but are yours, you need to make sure that all inventions are done off the clock, not using your employees' equipment, tools, and time. and you're not being asked to do that invention. If it's totally different from your job, not using your company's tools, equipment, resources, and you're off the clock, almost every case, you're going to own that independently. Get a hold of us. Let's move forward with your invention. Take care, everybody. Have an awesome day. Go big, go bold.